Right off the bat, this is where things get interesting. The court is addressing a potential conflict of interest and in legal terms that can make or break an entire case, but watch closely, because both sides are about to downplay it.
All those have been before the court draw near, the honorable Justice Day subject to resign.
You may be seated. Oh, who's that? How are you?
How are you?
We'll see. All right.
We've been successful topic before in the Office of the Public.
Notice how casually they dismiss the conflict. That's not always routine. Normally, conflicts can lead to attorneys being removed, but here everyone's agreeing to waive it. The real question is, why is no one pushing back?
Defender with the beliefs of the conflict that exists, we're going to follow.
Mike Gaddy, Assistant Public Defender on behalf of the Public Defender's Office, Your Honor. We concur with the people that we do not think any conflict exists. To the extent any conflict does exist, we would waive.
The court, for its part, also does not believe that there's a conflict either under Michigan court rules or the case is decided. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case of the people of the state of Michigan versus Michael Bank.
Good morning, Your Honor. Jacob Kennedy, on behalf of the people.
Morning.
Your Honor, Michael Gaddy, Assistant Public Defender on behalf of Mr. Bank, who is with us via Zoom. If you could state your name, Mr. Bank.
Michael Bank.
Thank you, sir.
Your Honor, I'd ask the court.
Adjournments like this might sound boring, but they're actually strategic. Defense attorneys often request more time to strengthen their case, meet clients properly, or even negotiate behind the scenes. Translation: something is still being worked out.
For maybe a 2-week adjournment in this matter, if the court would deem fit. I did meet with Mr. Bank via the video visitation method from Oakland County. It's I believe that given the nature of this file, we need to meet with him in person. It's time limited and the sound isn't very good.
All right. Any objection?
No.
Probable cause conference, April 30th, 2026, 9 a.m. Bond continues.
Thank you. I'll come visit you, Mr. Bank.
Mr. Bank.
Okay. Appreciate it, Your Honor.
Court does call the case. People versus Deshawn Gainey. Gainey.
Yes, I'm here.
Yes, I got you. I'm trying to get your attorney to give me an appearance. Hang on a second, sir.
Joy Gaines, Senior Assistant Public Defender. Good morning, Your Honor.
Mr. Gainey, can you state your name, please, sir?
Deshawn.
Thank you. All right, what do we do?
Your Honor, at this time, at this time, we would ask.
Another adjournment. If you're keeping count, that's a pattern. Multiple delays across cases in the same session usually signal overloaded systems or cases that aren't ready for prime time. Either way, justice is taking its time.
For an adjournment so that we could make arrangements to meet with Mr. Gainey in the Department of Corrections.
Yeah, is there going to be a problem with JCF in terms of getting in to meet him, or?
I would ask for 3 weeks. I have not worked with this facility yet.
Probable cause conference without objection will be adjourned May 7th, 2026, 9 a.m. Found in this matter will.
Michelle's case.
Thank you. And I'll need a green sheet.
Yes.
Thank you, Mr. Gaines. Court does call the case People versus Ryan Milligan.
Senior Assistant Public Defender representing Mr. Milligan. Your Honor, I've had an opportunity to discuss this case with Mr. Milligan, as well as with Ms. Cinda and the circuit court attorneys who will be handling his case before Judge Slay. At this time, the prosecutor has
Now, this is a turning point, a plea deal with time served and no additional jail time. That's huge. It means the prosecution is willing to settle possibly to avoid trial risks. And when both sides agree like this, it's often the fastest way out of the system.
To a sentence agreement of upon a successful plea to guilty as charged, Mr. Milligan would, they would agree that Mr. Milligan's sentence would be credit for time served, no additional incarceration. In talking to my colleagues in circuit court, we're going to waive that in order to secure that also with Judge Slay and are asking for a pretrial date.
That's correct, Your Honor.
All right. Mr. Milligan, you're gonna waive your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir, Mr. Simpson.
All right. People also waive their right.
Thank you, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Ms. Gaines.
Your Honor, we acknowledge receipt of the information, waive its reading on the record. At this time, my client will stand mute and enter a not guilty plea.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter,
April 30th at 1:30 is Judge Slay.
April 30th, 2026, 1:30, Judge Slay.
Thank you.
Thank you.
And will continue. Thank you, sir.
Thank you, Mr. Milligan.
Thank you.
Yeah.
Court does call the case of the person. Chidra. Hold on. Ikiji.
Good morning, Your Honor. Thank you, people. Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji for his case ending in 1678.
And
Mr. Ikeji's coming out now.
Assistant Public Defender Jay Bellinger on behalf of Mr. Ikeji on all the remaining matters, Your Honor.
All right, what are we doing?
Your Honor, may we request, and it's for all four cases, a 1-week adjournment. When we were here last time, we had thought and the prosecution had agreed to a mental health court disposition. Unfortunately, between now and then, he was not accepted into mental health court. And so we are working out what we hope will be a HIDA disposition, but we need 1 more week just to figure everything out.
Is everything going to be able to be figured out in a week? I don't want to get here in a week and then be adjourned again.
Your Honor, I'm optimistic that we will get there in a week.
I appreciate your optimism. That doesn't answer my question.
I do think we're nearing a resolution. We have several matters that we're trying to sort of get together in one big global.
We about to tear.
I know. What was that? Oh, okay, never mind. I just thought all in this with us. Mr. Bellinger, do you think a week's gonna do it?
Your Honor, I do. Based on our conversations, it sounds like we may be waiving everything up as early as next week. So I believe a week would be just fine.
Probable cause conference, April 23rd, 2026, 9 a.m. Bond continued.
Your Honor, could I ask to address bond?
Yes.
So it's been over 180 days for
This is
Mr.
where the
Ikeji.
stakes get
Certainly, if it's a
personal.
HIDA
Bond
disposition,
decisions aren't just paperwork.
he
They determine
gets
whether
more
someone
time
waits
than
for
we
trial
would
behind
expect to
bars
see
or
there,
at home. And when
significantly
mental
more
health
time.
is brought into the
He
conversation,
is doing
judges have to
extremely
balance
well.
risk,
Mr. Bellamy
recovery, and
I
public
both
safety all at
observed,
once.
For Mr. Ikeji, certainly if it's a HIDA disposition, that's more time than we would expect to see there, significantly more time. He is doing extremely well. Mr. Bellamy and I have both observed the changes since we first met him several months ago and where he is now, as has the Forensic Center with their prior evaluation, their more recent evaluations. There actually is a finding there of not guilty by reason of insanity if he were to pursue that route. His family is extremely supportive. Both his mom and his dad are here today. And I'm confident based on my meetings that he would do well on our request is home confinement. He would continue to get the medications he's getting. He'd work with community mental health services. And due to the amount of time he spent and how well he's doing, that's our request.
Anything else from anybody else?
No, it's perfect court.
No, Your Honor.
All right. I won't say I won't consider it next week, but I'm not gonna do anything now. Motion for bond reduction denied.
Thank you.
Court calls case People versus Allen Folks.
Ashley Feltus for the people.
Good morning, Your Honor. Wendy Barnwell, P42-505, on behalf of Mr. Folks, who is in the courtroom.
Yes, he is.
And good morning, Miss Barnwell. Long time no see.
Yes, Judge.
Your name, sir?
Alan Folks, Your Honor.
All right, what are we doing on this case?
Your Honor, I'm requesting a preliminary examination. I do
All
have
right.
electronic and paper discovery.
All right, thank you. My date is the
April 28th.
people also, will they have your witnesses available on the 28th?
Try for that date, Your Honor.
Preliminary examination in person for 28th, 2026.
Your
9
Honor,
a.m.
I do have, sorry about that. I do have
I should have known.
another. Well, it's in downtown Ann Arbor, but I think I could zoom on that one. I think so. That's a sentencing.
Oh, you've got
one
something
second.
in downtown Ann Arbor that you think you might
Yeah.
need to zoom in. Okay,
I'll zoom
think
into
we can-
that one, but I'll come physically in for this one.
all right, very good. 28th, 2026, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond continued. Thank you.
Same courthouse, Mr. Folks, same courthouse.
Yes,
We'll
ma'am.
talk. Thank you, Judge.
said-
Have a good day, everybody.
All right, you do the same, Ms. Barnum.
Yes.
Court does call the case, People versus Devon Thompson.
Ashley Feltus for the people.
Morning, Your Honor. Marcia Krejci on behalf of Mr. Thompson, who's approaching.
Your name?
Devon Thompson.
Thank you.
Your Honor, we have two requests today. The first request is we'd like to proceed to preliminary exam. I believe discovery is complete. We have a sort of a special thing in mind that,
That's correct, Your Honor. This defendant's co-defendant, Boston Henning, is already set for preliminary examination on the special setting before Judge Freshour. And I would request. that-
Okay, what date is that?
It's April the 29th at 1 p.m. at the 1484 District Courthouse.
That's the co-defendant to this case.
That's correct. And
Fresh hour, know it's coming.
I believe so. I was emailing with Ms. Ostrowski yesterday about this.
that date came about with the meeting that we had, with Judge Freshour.
All right. And I'm presuming then the people would have their witnesses available. That
We'll
day.
do our best, Your Honor.
All right. Preliminary examination, April 29th, 2026.
The
What,
sec-
sit at
1 p.m., Your Honor.
1 p.m.
the second request comes from my client. He would like me to address bond briefly.
Go ahead.
My client stands before you, a young man who was 17 when this incident allegedly occurred. I believe his criminal history at the juvenile is pretty, I think he's got a CCW, if I'm not mistaken. But after that, there's nothing else. He does have family in the area. He's resided here his whole life. He explains to me that he'd be able to currently reside with his grandmother in Ypsilanti, and that he is needed to help with childcare of his younger siblings. And so he's asking that the court allow him 10%. If the court does, we'll be asking for a PR bond in this matter. He'd be willing to do a house arrest on tether. That's our request today.
Your Honor, the defendant was involved in the planning and execution of an armed robbery where the item to be stolen was a firearm or firearms. The defendant has 2 firearm-related charges, CCW and reckless use of a firearm while a juvenile in 2025 and 2024 respectively. In this case, a victim and a co-conspirator were both shot. So I do believe the cash bond as that is appropriate.
So 2 people got shot in this whole ordeal. Motion for bond reduction denied. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Aaron Brandon.
Your Honor, Marcia Krejci on behalf of Mr. Thompson.
Aaron Brandon.
Ashley Feltus for the people.
Court does call the case of the People versus Aaron Brandon.
1 p.m., Your Honor.
1 p.m.
Alexander on behalf of the people.
Albert Riddell on behalf of Mr. Brandon, who should be appearing by Zoom. Oh, Mr. Brandon.
Here, Brian.
Thank you. Here we go.
Evidence amended. This should have been charges by the officer defense rather than police. Prepared a to expect domestic violence charge. Then I'm intending to move to dismiss count 2, the count defendants are ran on or add the count 3 of the top domestic violence charge. And I did send that.
Any objection to that, Mr.?
No, Your Honor.
This time I will dismiss count 2. We will do the arraignment on then the count.
Stand mute, waive formal reading.
All right. Bennett, waive formal reading and standing mute for will enter not guilty, please.
As to the probable cause conference today, just asking for an adjournment. I was just appointed very recently. I have my green sheet here for to hand to your deputy.
Probable cause conference will be adjourned to May 7th, 2026 night. But let's bond continue. Thank you.
Especially on the way.
Court calls case People versus George Wright.
Alexander on behalf of your honor. Moving on to Marshall Patron on behalf of Mr. Wright, who's approaching. Bless you. Bless you again.
All right. Her name, sir?
George Willis Wright.
Thank you.
Your Honor, we'd be requesting a preliminary exam in this matter.
You have all discovery.
Yes, I do, Your Honor.
Your other witnesses available the 28th. Preliminary examination person at the 28th, 2026, 9 a.m. before me.
Your Honor, my client is asking me to make a request to for a PR bond, if I may, briefly.
Briefly.
So, Your Honor, my client stands before you. His last convict leave for any crime was in 2024. Further, most notably is my client has some health issues that require some surgery. The first one is some eye issues that require surgery at the Kellogg Eye Center, which he tells me he has surgery scheduled for April 20th. Is that correct?
Yes.
Okay, and that he also needs to follow up with a surgery in his abdomen that requires follow-up. He has been able to secure housing at Miller Manor that so he has no family there in the area to help him. Therefore, he needs to be out and about. Specifically, he needs to be able to get to his bank account for bond. What I'm being told by my client is, if the court is unwilling to reduce the bond, is that his phone privileges have been prohibited. I don't know if that's true or not, but because I haven't been able to research that through the jail, but he's asking to have phone privileges. So if the court is unwilling to give him a PR bond, then the court would be, he can then make arrangements with a bail bondsman.
Prompt.
Your Honor, at this time, the people are going to be objecting. This is the case. Was strangled by the defendant to the point of unconsciousness and wants to share with the defendant or I'll kill you, bitch. He has a very lengthy history of domestic violence, including a DV conviction in 2010, 2 FAs from 2015, a DV conviction in 2019, and ongoing aggravated DV from 2019 for the 2023 domestic violence conviction, along with the dismiss DV for 2025. So at this point, I'm objecting. As to the phone privileges, I don't recall that being revoked. I don't believe that was the trust at arraignment. So
I don't see that. I ordered it. So I don't.
Right. My client says it's from a previous incident case that it was convicted, but, if it is, then I guess a stipulated order from the court.
I'm not stipulating any. I don't know why they're revoked. It may be proper that they are revoked because I had contacted the victim. So I'm not going to agree to anything regarding that. You can talk to the prosecutor about that. And
All right.
I'll
All right.
with it, but I'm not agreeing. I want to make it clear. I'm not agreeing to restore anything.
Sure.
Motion for Brown reductions denied. Bond will continue.
Thank you, Your Honor. Bond reduction denied.
And just like that, case after case moves forward, some delayed, some negotiated, and some denied outright. But beneath the routine courtroom rhythm, every decision here carries real consequences. The question is, which of these cases will come back with a twist?